Well, I've been fortunate. There are many that I could talk about, but I'm picking one. This one was tried to a jury in a major federal court, not in New York, in Michigan, 10 years ago. I won't identify the case by name because of some of the things that I'm going to be relating in the context of this my answer to your question. It was a manufacturing case, heavy manufacturing. Our client was a manufacturer and supplier of customized parts in the particular industry in question. And if I identified the industry, it would be easy enough to identify the parties, and I don't want to do that. The defendant was the purchaser. It was a giant company. It was the largest company in the world in its industry. And it had a long-term requirements contract with our client, the supplier. A requirements contract, in simple terms, just means that every part of the subject parts that are described and called for in the contract are parts that the defendant buyer was obligated to purchase from our client. The problem was that the defendant buyer treated it not like a requirements contract, more like an option contract. When they wanted to buy parts from my client, and we're talking about hundreds of thousands of parts over years, they bought from my client. When the defendant wanted to buy elsewhere because they found a better price or for whatever reason they wanted to do that, they either concealed the fact that they were making these purchases, or they contrived excuses, which were nothing more than lies. There were many, many, many millions of dollars that we sought in contract damages. We were trying the case in one of the more conservative communities politically and socially in the United States. I had been told by lawyers who I knew in that community that there was no chance of getting more than a low seven-figure verdict, which was not nearly an adequate amount of damages. You would have no chance with a local jury of doing any better than that. I told that to the client. We did the best we could. What were the keys to what wound up being the largest commercial verdict that had ever been obtained in that court, ever? The most important thing was the work that my team did, because trial work is very much a team effort. And the team consisted of the client's personnel, and a raft of lawyers in my law firm who supported me and put me in a position to frankly demolish the executives from the defendant corporation. One by one, I showed the jury that they lied, that they cheated, that they prevaricated. They did everything they could but tell the truth, and they tried to do that with the jury, and I caught them in lie after lie after lie, to the point where even though this could have been a boring case because it involved hundreds and actually thousands of purchase orders and other kinds of business records that would put an insomniac to sleep, I was able to get the jury. You could see them. I would only look at a jury out of the corner of my eye. You never want to stare at the jury. But I could see that they would, as I rose to cross-examine after they saw the first part of the first cross-examination, they would go right to the edge of their seats, like they were watching an exciting movie, except it was happening in real time and in real life in this courtroom. So they were fully engaged, which is very, very important. They tried to understand. They took notes. Some judges don't allow juries to take notes. This judge did. So all of the cross-examination of their key witnesses were essential to the case. And I will say, we had a hostile judge This is really the only time this has ever happened to me. There were times when he called me to the bench and said, "Counsel, I don't like your cross-examination. You're cross-examining these witnesses too hard." I said, and it was true, I said, "Your Honor, I've tried cases all over the United States, including many in Michigan, because that's where I'm from. And I've never done it differently than I'm doing it now, and I've never had a judge tell me that I was cross-examining a witness too hard." And I just stood up to him and kept going. And he didn't like it, but there wasn't really anything he could do about it. And lastly, the client himself was ferociously smart, very successful, and to put it nicely, an extraordinarily self-confident entrepreneur. He did think he was the smartest person in the room. And I said, you can't present yourself to a jury that way. You've got to get down to earth. You've got to find some humility. You've got to not engage in chest pounding. And I worked with him, along with my team, on and off for weeks before the trial, getting him to the point where he didn't do things that were highly likely to turn off the jury. And I would say those were the keys to the case. And as I say, when the jury came back, talk about chest pounding, I could hear my heart pounding. And they gave us almost every penny that we asked for. It was an unforgettable case. It went on for about a month. I remember being driven home the next day. I was so exhausted, but it was a fabulous experience. As I say, there have been many others. That's one.